you must keep it as confidential, because the breach of confidentiality may attract civil or regulatory sanctions against the university. Then contractual obligations. Once we enter into contract with stakeholders, other contractors, you must respect what we have stated we will do in the contract. The intellectual property is also an issue in the university administration. Once we produce our work, which is original, you must register. We have Madam Eunice around. He's in charge of some of these intellectual properties. Then we have a vicarious liability. That's under administrative liability and ethical responsibility. So we have vicarious liability. And this is a principle in which when an employee incurs any liability in the course of his work, the employer will be held liable. It is not you, the employee alone, who will be held liable. So if you are an administrator, in the course of your work, you commit any tort or any civil wrong against a third party, the university will be held liable. When we are negligent in maladministration, so failure to follow due processes can lead to lawsuit or reputational damage. So when our name is always mentioned at the court, it is giving us a reputational damage. The conflict of interest. We have situations where your personal interest conflict with that of the university's interest. You must avoid from that. The compliance and monitoring. So regular internal audit and legal reviews help prevent administrative lapses. Now, administrators as repository and interpreters of statutes. So as administrators, wherever we are assisting the academics. We are assisting the academics. So you must have fair understanding of our laws. Various policies we have, both internally and externally, you must have fair idea of them. So some of these are the university statutes, which is under review currently. You have the appointment and promotion criteria. There was a case which a professor applied to be promoted, I think to full professor or isoprof. With isoprof means that he was senior lecturer. And so the recommendation to AMP was, among them, was that the person had not attended conferences within the years that prior to his application. But you see, attending conferences may be good, but we work within the rules. When we go to appointment criteria for appointment and promotion, there is nothing like attending conference. And so when we do that, we expose ourselves to legal suit. The person can take us to court. That this is our criteria for appointment and promotion from maybe senior lecturer to ASUPROF. There's no provision, no item which says that I should attend conference before I qualify for promotion. But we are using that against that person, and we are exposing ourselves to legal suit or lawsuit. So we must also have fair idea, financial and source regulations. I think they are there, we know them. Yes, so let's proceed. Also, then other external laws. Yes, we have the University of Cape Coast Act, which we must know, the Data Protection Labor Act, Public Procurement Act, and regulation. You must have fair idea as administrators of these laws. Then let's come to the powers and limitation of administrators. This is very important. This is a constitutional provision. Article 23 of the Constitution says administrative justice. You see, earlier I said that our source of power comes from the sovereign people of Ghana. And so we must exercise our powers to the welfare of these people. And so the Constitution is saying that administrative bodies and administrative officials, which all of us are, we are all administrative officials, shall act fairly and reasonably. We must act what? Fairly and reasonably and comply with the requirement imposed on them by law. You see, we must act fairly and reasonably and comply with the limitation imposed on us by law. Now, it goes on to say that a person aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunals. So anytime we fail to act fairly, anytime we fail to act reasonably, anytime we fail to comply with the limitations imposed on us by law, any person aggrieved, and these days it is not the persons who are directly affected who go to court. Other persons are now going to court because of the actions of the university. So, Article 296 also gives us, as the university administrator, we may have discretion to transfer one person or other to another place. So, in making the decision, we are exercising discretion. Discretionary powers can be abused. And so, the Constitution gives us the parameters within which to exercise our discretionary powers. The Constitution says that where in this Constitution or in any other law, so it may not be in the Constitution, but any other law, including the University of Cape Coast Act, and in any other law, discretionary power is vested in any person or authority. That discretionary power shall be deemed to imply a duty to be fair and candid. So you see certain words keep recurring: fair, 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 and being what? Candid, being honest. Then it continues to say that the exercise of the discretionary power shall not be arbitrary. So it's not like I like this person, I don't like the other person, so I'm giving this favor to this person as against the other person. No. Then, yes, arbitrary, capricious, or based either, yes, capricious, or based either by resentment, prejudice, or personal dislike, and shall be in accordance with the due process of law. Then it goes on to say that where the person who is exercising that discretionary power is not a judge, then there must be published a constitutional instrument or statutory instrument to regulate the exercise of that discretionary power. So once we are administrators, every action we take, you must have in our mind that this action is based on one policy or the other. That is giving me the power to exercise in this manner. So, administrative bodies, okay, I think you have seen this one. Okay. No, I mean, there are some case laws I want us to look at in enforcing. Yes. So we have question order. When administrators take decision which is contrary to statute or which fails to comply with the procedure, any person affected can go to court for that action to be quashed, to be set aside. So that's the question order. So I have a case law for us to look at. This is a case of Awuni versus Wayek. It was a case in which in the year 2000, during the administration of the WASI examination, Wayek detected that about 13 students from Notre Dame Secondary School in the Northern, I think up. Yes, Notre Dame Secondary School. Their answers were the same. And so Wayek took the decision. It was mathematics paper 2. Yes, Wayek took the decision based on Wayek's own expertise to cancel the mathematics paper of these 13 persons. So when the news got to the headmaster wrote to Wayek and he says that The allegation were unproven, and that Rule 56 had been applied unfairly without proper investigation. See, why didn't do any investigation? By the fact that the answers were the same, the WAEC concluded that they copied. And so the headmaster further said that there was no evidence of leakage or collusion during or after the exams. There was no evidence. WAEC has no evidence to that effect. Then similarities in answers could be explained by student reliance on common textbook. That's Akiola. This is what the school was saying. WAEC, however, rejected the petition. This was the petition from the school. WAEC rejected it and maintained the sanction against the student. So the matter went to High Court. It went all the way to Supreme Court. So let's see what the Supreme Court said about the actions of administrative bodies when we are taking a decision that affect third parties, what we should do. So this is what he said. Where a body or officer has an administrative function to perform, the activity must be conducted with and reflect the qualities of fairness, reasonableness, and legal compliance. So these are the three ways: fairness, reasonableness, and compliance, legal compliance. I will not venture to give a comprehensive definition of what is fair and reasonable, since these qualities are dictated by the circumstances in which the administrative function is performed. At the very least, however, it includes, these are the words: probity, transparency, objectivity, opportunity to be heard, legal competence, and absence of bias, caprice, or ill will. Yes, in particular, where in this case the likely outcome of administrative activity is of penal nature, no matter how strong the suspicion of the commission of the offense, it is imperative that all affected persons be given reasonable notice of the allegation against them and reasonable opportunity to be heard if the objective of Article 23 is to be achieved. And so this guides us that whenever we are taking a decision that will go against a third party, we owe it a duty to be fair, reasonable, and give the person a hearing. It's very important. It doesn't matter how strong the suspicion is. So let's look at another one, KKA Abraham versus UCC. This is also something that happened at the university's appeals board. This person applied to be employed as a lecturer. He was duly employed as such. He served and qualified for promotion to senior lecturer. He applied, it went through all the processes, and then a report came that he was successful. Congratulatory messages went to him from all manner of people. So, 2 years later, after serving on senior lecturer rank, then a letter was served on him, I think from AMP, saying that his promotion is to be withdrawn. In fact, has been withdrawn. Why? Because when he was around the time he was employed, UTAG wrote a petition to council saying that some unqualified persons had been employed as lecturers and senior lecturers and so on. So council set up a committee in 2016 to investigate it. During the investigation, this man was never contacted. But the investigation committee made a recommendation that affected him, that he should get his PhD before the next promotion. He never knew of it. And so when this information came to the attention of the AMP, they wrote to him revoking his promotion to senior lecturer. So he petitioned the university appeals board. So let's see what the appeal board said. It said the conduct of AMP board in promoting the applicant to senior lecturer, the appeals board presumed that he satisfied all the requirements, and therefore the AMP board was stopped from withdrawing or withholding it as it sought to do. So by you, the board, taking this man through to get his promotion, it is presumed that he satisfied all the requirements. Then he went on to say that, secondly, the 2016 ad hoc committee, in conducting its work that affected the appellant, failed to give him an opportunity to be heard. You see, it doesn't matter that he really did not qualify to be appointed or promoted to senior lecturer. But the fact is that he was not given a hearing. So once he was not given a hearing, then anything that you do had to be set aside. So the appeals board set aside the letter withdrawing his promotion to the rank of senior lecturer. The last one I'll look at is the Kevin Taylor's case. I remember recently, Kevin Taylor went to Supreme Court. So this was a man, a case was pending at the High Court. Then a video was shown to the judge that Kevin Taylor was making a scandalous statement against the judge. And so the judge, without hearing Kevin Taylor, issued a warrant of arrest to come to court, why he should not be punished for contempt of court. You see, so the arrest was warrant was to last until he dies. So whenever he stepped to the shores of Ghana, he has to be arrested. So Kevin Taylor went to Supreme Court and challenged the decision of the High Court. And what he said was that the court, he said the court described him as a scoundrel. Let's proceed to the next one. The grounds of, yes, I think before that one. The grounds for the application. So this is what he said, the lawyers were saying. The High Court acted in breach of the Odi Authorium pattern rule by not allowing Kevin Taylor to be heard before issuing the warrant. You see, what he is saying is that if we are issuing a warrant for my arrest to be sanctioned, then you have concluded in your mind that I am guilty. But you must hear me first before you pronounce on my guilt. Then that's why he said the warrant was not issued in accordance with any sanction legal procedure. The next one, the High Court erred by directing Taylor's arrest before providing an opportunity to be heard on the allegation. So let's see what the Supreme Court said. The Supreme Court found the High Court's action violated Taylor's constitutional right and lacked due process. Then it also said the Supreme Court granted the application for certiorari to question the warrant of arrest against Kevin Taylor. The ruling emphasized the need for fair hearing and due process in contempt proceeding. So, in a nutshell, all that we are saying is that when we are administrators and we will take decisions against third parties, against individuals, we owe it a duty to give the person a fair hearing before we come out with that decision. If we don't do that, then we are making ourselves available for a lawsuit against the university. Thank you very much. Because of time, I have to end here.
Thank you very much, Mr. Jesse. Please pardon us. We have made you rush through. You are left with 10 slides to go. But President says that he would have Gawa organize a webinar so you could present the entirety of the presentation to all of us to our benefit. So, ladies and gentlemen, you will have the benefit of going through again for full understanding. Please, time for us to take, President, this time 3 or 5 questions. Two. And no question, 5 people more must see. Joe. Felix. Microphone. So 1, 2, 3, 4, 5. After.
Thank you very much. This one goes to my counsel. Yes, that was a wonderful presentation. So I know there's a law that allows citizens to change whatever, their buy data. And so we are talking law, we are talking administrative, operations. So where I sit, I admit students based on their WASSCE results, which come with date of birth. Midstream, this student comes to me to say, I have changed my bio data. Do I take the new one, or I insist to use what the person brought on first admission? Similarly, as a staff, very soon I'll be going on retirement. If I go to change my date of birth, will HR admit and say you can grow younger?
Right.
I want to know. Thank you.
One question. One man, one message. Ernesto.
I have 4.
No, one.
Yeah, to me choose who they are.
The last one.
Okay, so please, this question that I'm asking is without prejudice to any. It's for academic.
Enough for the preamble. Please go ahead.
It's for academic purposes. I have been given an appointment letter as a sectional head, and it's for 3 years. I have just consumed 1 year. If I'm giving another letter that they are transferring me from where I am now to a different location or session, what are the legal implications? If the staff decide to test
Right.
the law, is there any...
Right. But do you remember what the party chairman said?
Then the last one is the notice board. The students that we have been displaying on the notice board.
Please, one.
May I just information? The students on the notice board, they're dismissed students. Any legal implications? Thank
All right. Right. So, Mauli.
Thank you for the opportunity. My concern has to do with my data with Prudential Bank and me being asked to go and pick my staff ID card at Prudential Bank. I want to know if there are some legal implications. Thank you.
All right. I refer all of you to Mr. Asedun Ketia.
Thank you. Please, mine is about the data protection and rights to information. As administrators, when people are requesting information from us, which information is within our jurisdiction, as far as data protection is concerned and RTI is concerned, how do we release such information? The last one is information. Now that we have birthday retirement dates, if you are retiring first week, maybe you've done 1 week or 2 weeks and you retire, what happens to your salary at the end of the month? Thank you.
Okay. So, I believe that Solo has influenced all of you. All your questions are on legal matters. But what matters most? Very soon you go home. Mumbisa other questions. So the last one and then we are done.
Yeah. Thank you so much. Mine too is on legal issue. And
Please do.
Mine will be based on right and fairness. I just want to ask our council that if one is a unit head and they do equal work with some people, which are also a unit head, but they are taking allowance and you are not taking, do I have right to also demand that I should be paid by fair payment, or is it fair?
Right. So, once again, reference Mr. Asedun Ketia. He says go to court.
Thank you very much. In your presentation, you mentioned that when you were listing some of the stakeholders of the university, I noticed that you had listed parents as stakeholders of the university. And I began asking myself, where is the PTA version of the university? If it isn't there, then it means that the university may not be doing enough to recognize parents as key stakeholders in the universities. Any response, please?
I think some of these questions, registrar may help me because it okay, so the first one is on the change of name. This one, yes, change of name and change of date of birth. This one, there's a case law. Somebody came to us and he wanted to change. He was a sandwich student. He wanted to change his name. We gave him assurances. And that's what we should know. When you are writing a letter to a Senate party, you must know what our laws and policies provide. We had apparently given him a letter assuring him of the processes to change the name for him. Only later to hit the rock that we can't do it. So he took us to court. The court said that, in fact, in the judgment of the court, the judge did not avert his mind to the Data Protection Act. So he used, let me say, common sense to give us the judgment. We won the case all right. The judge said the universal application of the policy that we don't accept any change of name is not fair. But when we also want to tolerate change of name, but we had argued that we want to protect the sanctity of a certificate we issue. Because somebody will bring his name for admission. He can use somebody's name for admission. Only after the admission to turn around to come and give us what his real name. So the court also said that if we want to change name, then we are going to change the registry of the university as investigative machinery, where you have to go around to investigate whether the person who is coming to change his name is actually genuine or not. And for that matter, the judge agreed with our policy not to allow change of name. However, in fact, this matter is not settled because of the Data Protection Act, which gives citizens the right to amend their records. Yeah, so I remember Justice Eniyebua, whilst at law school, he said that there was this man who had changed his date of birth. He was apparently very old, exceeded the 60, going to 70. But because of the date of birth he used at the workplace, he could not go on retirement. So what could the judiciary do? He was working at the judicial service. So they advised him to swear an affidavit. Yeah, to state that he made an error in the original date of birth he used when applying for the employment. And based on that, the judicial service accepted and then allowed him to retire. So I think that, personally, I was developing a write-up to registrar on the need to align our policy on change of name to sync with the data protection. Because if somebody goes to court with this advent of the Data Protection Act and challenge it, for us to argue on the remit of the law, we may find our policy wanting. But at the time, there was no mention of the Data Protection Act. So we had our day in court on that issue. Then the transfer issue. In fact, transfer is the right of the employer. And transfer is not punishment. Yes, the only thing that may happen when your scheme, you have been disadvantaged. So you have been transferred from one place to another, all the remuneration are the same. It's not a punishment, and for that matter, I don't think you can get any success in court when you pursue in court. The employer has the right to transfer the workers, the employees. At any time, yes, but you must give reasonable notice. Yes, when you give the transfer, it takes time for you to prepare to move to another place. So when you don't give reasonable notice, that is where problem comes in, whether your action is reasonable or not. Then other questions on, I forgot some of the questions. Yes, after we have to, I think, Gawa, the next time we have to do a lot of, when we have the webinar, we have to bring the data protection issue. Yes, so that we talk about that one fully. Currently, when the issue of confidentiality, when somebody's information is in your possession and you decide to disclose it without an order from the court, in fact, there are exceptions. We apply to the police institution to give us information. They said they are exempt. So it is not every information that you have to give out unless there is an order from the court. So in case there's somebody makes an application to you to provide information to him, and you are not convinced, just refer the matter to us. We will study and advise you appropriately. Instead of you on your own giving out the information, you will risk putting the university into a lawsuit. Yes.
As a faculty officer or somebody working within any directorate, when such information comes, you don't have the right to give that. The first point of call, you have to go to the registrar. Before the registrar will study, then he will give you the right direction. Thank you.
Thank you very much. I think it's on point. Then I think which other question? Yes, that I also have my challenge on that. The privacy of the person. I have my challenge, but for this one, let me consult and then I give you appropriate. But I personally have my challenge. When it's about success, that's okay. Somebody has been appointed, the whole world. In fact, there's even a developed right, which some people in the developed countries have sued Google. The right to be forgotten. That's an emerging right. Yes, so if my name, I am convicted, or my name is in Google online for a bad reason, it shouldn't be there forever. So I think Google was given 10 years. After 10 years, you have to remove the information from Google. So the right to be forgotten is also a new emerging right. Yeah, the right to be, yes. Then the parent issue. The parent, I think, registrar should help us. The parent as stakeholders. In fact, I think when lecturers are on strike, who are the most affected? Apart from the student, the parents complain a lot. So the parents are also serious stakeholders in the university education. After all, they pay the fees. Yes, so I think, but I'm not too sure. When we started university education, the students were all matured. Yes, so the need for parents to come in. So that could be a proposal that you have to explore. Whether PTA has to be part and have a meeting with the management. And thank you very much.
Right, thank you very much, Salo.
No. Equal work. Yes, that is the fundamental principle of labor law. Once we are all working, doing the same work, then we are entitled to the same pay. We should not be discriminated. I can't. Student. Yes. Our staff. Oh, okay. So see, that's what I said. When it comes to this issue, let's have another webinar to make a full presentation on Data Protection Act. Data, even though university has the right to keep our information, there are restrictions as to what we can use the information for. So giving our information to a bank, I'm not too sure, without our consent, it may not be appropriate. But let me check the law properly on Data Protection Act, and we have a presentation on that. Thank you so much.
Right, thank you very much. So we try that the webinar will make things clearer than probably we have heard. So give it to the Araba. Man, got some pension, no. Psalm 23, us the shepherd. PH, Presbyterian hymn 555, us Yehovah, name Reshafu. The pension for you know, for one relation, and go pomo. Obedi. Director HR, I don't know Mr. for Asuma Mingaka. Provident Fund saying be no to me about 1 minute information. 1 minute per. Ediane no Jonesy.
Thank you very much, Mr. MC. The Provident Fund, it has gone far advanced, so it has gone through the process. Council has approved the fund to be implemented. And so a chairman has been appointed by the Vice Chancellor, and I think that they have started the process trying to inform staff about it. And the secretary is here, Goda, and she's the secretary to the fund. And I'm aware that it is in place, and very soon it will be rolled out for staff to also enjoy.
So, time for presentation. I'll humbly invite our registrar to do us the honors by presenting the citation for now to our main speaker. So, yes, you sit comfortably after Naomi has read, and I'll call you for you to walk gracefully, majestically, to come and receive it. Naomi.
In recognition and sincere appreciation of your invaluable contribution as guest speaker at the Continuing Professional Development CPD seminar of the Ghana Association of University Administrators, GAWA, University of Cape Coast, with deep gratitude, we acknowledge the time, expertise, and exceptional insights you delivered on the theme, enhancing stakeholder engagement in higher education, the role of the university administrator. Your scholarly perspectives and practical guidance have enriched our professional understanding and inspired a renewed commitment to excellence in higher education management. Your dedication to advancing administrative leadership and strengthening stakeholder collaboration within the university environment is commendable and worthy of emulation. Through your distinguished service, you have made a significant impact on the professional development of GAWA members and the wider academic community. We proudly present this citation as a token of our appreciation and respect. Presented this 29th day of October 2025. Ladies and gentlemen of GAWA, with one accord, shall we please call on Dr. Sena Peglo to receive the citation.
Right. So, to the organizers, a whisper into my ears from ES, she says that, please next time put my freku there. So those of you who, Joanna, many okasa, I will know citation. Asama makimenya some about brom rough, but I want to throw. And so, kindly be on your feet as you present to us your closing remarks.
Ladies and gentlemen, today we came together under the theme Enhancing Stakeholder Engagement in Higher Education Management, the role of the university administrator. We have come to understand that this is not an abstract idea. It is crucial for our institution's success in a rapidly evolving education landscape. Throughout the seminar, we explored the challenges and opportunities that shape our profession. Our knowledgeable speakers have expertly guided us through critical areas, and I want to take a moment to recognize their invaluable contributions. Our guest speaker helped us to identify our stakeholders, the concept of stakeholder engagement, the challenges of stakeholder engagement, the role of the administrator, strategies for enhancing stakeholder engagement, and then the future of stakeholder engagement. She ended with the core competencies of a future administrator. And these were strategic thinker, emotional intelligence, negotiation and diplomacy, adaptability and innovation, and then digital literacy. If there's one thing that I learned from my study of law, you know, I started studying law at an advanced stage. When I started, I was 42 years. So I had a big problem with remembering the cases and the provisions. One thing that really helped me was the use of mnemonics. So for this competencies of the future administrator, straight away I have SENA D, and I can remember it straight away. So I'll encourage you with that. Right. Our first presenter, Ms. Linda Otu, provided a fascinating look at the future, analyzing the impact of AI on effective administration and stakeholder engagement, demonstrating how we can use technology as a tool for progress. Dr. J. A. Kizzy-Hayford shared insightful perspectives on the importance of administrators' health, reminding us that our well-being is essential for effective engagement. In the process, we learned about GERD. I won't trouble myself to go into the details of GERD. The impact of GERD on administrative performance, how administrators' lifestyle fuels GERD, and then management of GERD. Dr. Philomena A. Sam challenged us to think forward with her presentation on retirement planning, a vital aspect of stakeholder welfare. She encouraged us to venture into entrepreneurship. Then finally, my learned friend, Solomon Jesse, laid out a crucial framework on the legal aspects of administration and stakeholder engagement, emphasizing that sound legal practices are key to building trust. He started with sources of authority, of legal authorities for the administrator, common legal issues, liability and ethical responsibility, in investor administration, administrative liability and ethical responsibility, and then constitutional rights. As we draw the curtain down on this CPD seminar, I stand here filled with gratitude and pride. Gratitude because we have been enriched with knowledge, insights, renewed perspectives, and pride because this gathering has once again demonstrated the professionalism and commitment that define university administrators in Ghana and Cape Coast for that matter. The true impact of this seminar will not be reflected in attendance of numbers, but in tangible changes we make in our respective offices as we move forward. I encourage every administrator here to take insights, strategies, and renewed enthusiasm gained today and actively apply them. Let's commit to making stakeholder engagement a continuous and proactive process, ensuring that every voice from students, faculty, to government and industry is heard, valued, and integrated into our university management. My fellow administrators, I urge us all to take the knowledge gained here back to our work and translate it into better service delivery, improved teamwork, and greater efficiency. It is important to understand that our universities depend on us, not only to keep the systems running, but to make them thrive. Let me take this opportunity to commend the leadership of GAWA for this foresight in organizing this program, and to our resource persons for the depth and clarity with which they shared their expertise. We are deeply grateful for your time and dedication. A special thanks to you, our general sponsors, the Institute for Education and UCC Credit Union. Fellow administrators, we are the engineers of our university environment. Let us live here today renewed in our commitment to excellence, integrity, and engagement. Thank you all. God bless us all.
Thank you very much, Registrar. And I trust that announcements are that after this, we all go down and take a group photograph, after which all roads will lead to Unicard for the washing stakeholder engagement. So, ladies and gentlemen, I will want to do the second part of the vote of thanks that Registrar did. We are grateful to all our directors, deputy directors, deputy registrars, and to all of us for attending this very wonderful program. It has been insightful. We trust that whatever has gone through our minds, we're going to implement them for the good of the University of Cape Coast and that of our country, Ghana. We say thank you very much. And so on the request of my president, or our president, I crave the indulgence of all who planned this meeting or engagement to be upstanding, come to the front so that we can acknowledge them. So, chairperson and members, please come to the front so that even though we know you, we can see you better. Please, let's do it for them. Meetings upon meetings, calls upon calls, they have made it possible. They have done it, and we are all enjoying the fruits. Yes, madam. Mom broom.
On mdundo.com.
Right, so this chairman and his members who organize this program, we are grateful, and the webinar is in your hands. The next two seminars are in your hands. We are grateful. Thank you very much. And once again, we want to thank our sister unions who were here. Two of them, Tvucc and then SSA Eugene, have left, but UTAG is still here. So now I invite Reverend Tvucc to give us the closing prayer. Please, they say be brief, because I don't know, I do that.
Sir, shall we please rise? We've been sitting for quite some time. Thank you. Shall we pray? Thank you, Heavenly Father, for a very successful event today. We thank you for all the speakers, the presenters. We thank you for the lessons learned. Our humble prayer is that the things we have learned stay with us, and you grant us the wisdom and ability to appropriate the lessons we have learned from today's presentations. We ask also that you graciously grant journey mercies to our presenters, particularly those who are from out of town, our guest speaker, and continue to make them resourceful and relevant in their generation. We thank you for hearing us, and we ask that you dismiss us with your blessings. We ask that the next session be a blessed one, and we thank you for hearing us in Jesus' name. Amen.
So on my own behalf and that of my colleague, we say thank you for listening to our voices. We trust that you enjoyed the time with us. Good afternoon.